13th, the desegregation of Alachua County schools is a fascinating story of how school administrators, teachers, parents, and students moved to a single unitary school system. Today, we will discuss what the federal courts mandated and why. On the 13th, the subject will be what happened in response to the court orders and the challenges faced by the community as a result. I'm pleased to introduce our speaker, Michael Gengler. Michael was the author of this book, A Community Takes on the Challenge of School Desegregation. We Can Do It. He's donated a copy of this book to the Okamic Library. Michael graduated from Gainesville High School in 1962. And I mention this first because Gainesville High School played a pivotal role in the desegregation of public schools in Alachua County in 1969-70. He received his A.B. degree from Columbia College in New York City in 1966, magna cum laude, and was elected to Phi Beta Kappa. In 1969, he received his J.D. degree from Harvard Law School. Until 1974, he served as an assistant staff judge advocate in the United States Air Force. For most of his career, he was a corporate lawyer in Boston and Chicago. He also worked for a few years as a full-time volunteer lawyer for Legal Action of Wisconsin in Madison, representing clients who could not afford counsel. He lives in Gainesville now and is a vocal advocate for public school education. We're happy to have him here for ILR today. He will present the first two sessions for our series entitled Milestones in Afro-American History. Michael?
Oh, and thank you so much, John. I appreciate the introduction and also the invitation to be here. I'm really very honored to be here because I know that many of you are academics and perhaps even a few of you are lawyers, and I think that the audience is perhaps an optimal one to do this presentation for. And I have presented at a number of other academic conferences, and if you're academics, you know that you get like 10 or 15 minutes to do your pitch, and you're on a panel, and this is a much longer session and will allow us to go into greater depth into the book. So I'm going to do share screen now, Julie. And so we'll be going through these PowerPoints as part of the presentation. This is the book. I wrote it, as John said, not to just tell what happened, but also to try to explain why it happened the way it did. And in particular, Alachua County, as John said, has a number of features that make it a very interesting story. Today, we're going to be doing the legal background. The legal framework is basically the house that the lawyers built in which desegregation took place. And we're going to do three issues. Here we go. Issue number one, which is still a very controversial issue. Should the Black community seek to desegregate the separate schools or make them equal? And the first case we're going to consider, how can I get rid of this? Oh, maybe like that. Okay. So the first case we're going to consider is Roberts v. City of Boston, Massachusetts, 1849. And why are we looking at this case? Well, we're looking at this case because this was a precedent in Plessy versus Ferguson, which came up to the Supreme Court in 1896 and decided that separate but equal was constitutional. So here we have the facts. Sarah Roberts, age 5, on the 15th of February, 1848, went into the primary school nearest her residence, but without any ticket of admission or other leave granted, and was on that day ejected from the school by the teacher. Does that sound familiar? Charles Sumner, the famous senator and abolitionist, was the lawyer for Ms. Roberts. According to the spirit of American institutions, and especially the Constitution of Massachusetts, all men without distinction of color or race are equal before the law. The fact that the separation of the schools was originally made at the request of the colored parents cannot affect the rights of the colored people. And here we have another significant issue that will follow us all the way through into next week, that some African Americans wanted separate schools and some African Americans didn't. And then Mr. Sumner is continuing his argument. The separation of the schools, so far from being for the benefit of both races, is an injury to both. It tends to create a feeling of degradation in the blacks and a prejudice and uncharitableness in the whites. That also is a very controversial statement, as we'll see. So what did the court do? Massachusetts, 1849, the court determined that the school committee had discretion to create different schools for pupils in different, more advanced age, greater proficiency, different ages, and so on, for poor and neglected children. Race is no different from any other classification that the school committee might decide to make in the public schools of Boston. And what did Justice Shaw decide? It is urged that this maintenance of separate schools tends to deepen and perpetuate the odious distinction of class. This prejudice, if it exists, is not created by law and probably cannot be changed by law. Whether this distinction and prejudice would not be as effectively fostered by compelling white and colored children to associate together in the same schools may well be doubted. At all events, it is a fair and proper question for the school committee to consider and decide upon. So that's the path that this country did not take. That's how they got the legal answer that segregation in the schools was okay. Now, after the Civil War, Congress passed civil rights acts, and there were proposals at the time that school segregation be included as something that would be forbidden under the Civil Rights Acts. Those attempts were rejected by Congress. It is not mentioned in the 14th Amendment, that is, school segregation is not mentioned in the 14th Amendment. So here we have the 14th Amendment. No state shall make or embrace any law which shall deny to any person within its jurisdiction the equal protection of the laws. After Reconstruction, Florida passed a new constitution in 1885. This is the constitution that was in effect throughout the segregation period. White and colored children shall not be taught in the same school, but impartial provision shall be made for both. So in 1930, the NAACP was looking into what are we going to do about school segregation. The problem was that in the South, we had great disparities in the expenditures that were being made for the Black schools. In South Carolina, at this time, more than 10 times was being spent on the white schools. Florida, Georgia, Mississippi, and Alabama, again, kind of bringing up the rear, more than 5 times was being spent on the white schools. And then these other states, more than twice. And so the NAACP is at a fork in the road. Do we sue to make the Black schools equal, or do we sue to desegregate them? And Attorney Margold, by the way, this report is online in the Library of Congress. This vicious situation represents the very heart of the evils in education against which our campaign should be directed. It would be a great mistake to fritter away our limited funds in sporadic attempts to force the making of an equal division of school funds in few instances in which such attempts might be expected to succeed. So here is the seminal document, the recommendation of a lawyer that the remedy that is to be sought by the NAACP should not be a campaign to make the schools equal, however that might work in some alternate universe, but they should go for desegregation. Obviously, either choice was going to have problems. So we move on to the second seminal document here for Journal of Negro Education, 1935, a yearbook which was devoted entirely to this issue. We have Du Bois, the first Black Harvard PhD, writing an article about the dangers of desegregation and the fact that Black kids would be mistreated in the white schools. And then he goes on to say, I know that this article will forthwith be interpreted by certain illiterate nitwits as a plea for segregated Negro schools and colleges. It is not. Elaine Locke, the first Black Rhodes Scholar, children will be able to work this out. Charles H. Thompson, University of Chicago, PhD, Howard University Dean, making the same argument that Sumner was making in Roberts v. the City of Boston. Not only is the separate school unequal and undemocratic, but it results in...
Why would I do that? It doesn't work.
And both races develop a misunderstanding of each other that necessitates all of the expensive and ineffective race relations machinery that we have in this country at the present time. I want to take a brief detour. Professor Kendi, many of you will have read this book, Stand from the Beginning. It came out as my book was in manuscript. I really didn't address it. I cited the book in the bibliography. And he's representing the opposite position here. The NAACP's attack on segregated education was elitist. You saw the backgrounds of the people who were making the decisions at that time, and racist. That the idea that African Americans in African American institutions were suffering irreparable psychological harm is a racist argument, and it also is an assimilationist argument. Now, I want to call everyone's attention to Judge Robert Carter, who was an NAACP lawyer from 1944 to 1968 and was in the front lines of this struggle. And what he is saying in this book review, in the Michigan Law Review in 1988, is that the NAACP strategy to oppose segregation rather than seek equal facilities was a national strategy. In other words, he's agreeing that yes, this was a top-down thing in the NAACP. Local units would have been satisfied at the time if the organization had opted for litigation merely to update the Black schools. Opposition to the NAACP's segregation strategy was so strong that Thurgood Marshall called a conference at Howard University in 1950 to allow opponents of that strategy an opportunity to make their points. And then he goes on, interestingly enough, Du Bois's presentation at the conference was among the most influential in gaining support for the all-out attack, in other words, for desegregation. From that point on, the NAACP focused only on desegregation. And Judge Carter goes on to say the belief that an equal facilities strategy would have produced greater rewards for Black children in the Upper South is a myth. So we have, perhaps an alternate universe here. There are 2 points of view, but the one that prevailed was that to go for desegregation. In the Brown litigation, there were 5 cases involved in that Supreme Court decision. Davis v. County School Board of Prince Edward County. Let's look at what the school boards were arguing in favor of segregation. Professor of Psychology Henry Garrett, Columbia University, testifying for the school board, February 1952, the Negroes might develop their schools up to the level where they would not want to mix themselves. And I would like to see it happen. They would develop their sense of dramatic art and music, which they seem to have a talent for, and athletics, and they would say, we prefer to remain as a Negro group. Well, that's something to consider. John W. Davis, representing the defendants in Brown v. Board at the Supreme Court. Davis ran for president against Coolidge in 1924, cited the 1935 Du Bois article as authority favoring segregation. No one called him on it. And of course, that would have been a charge of misleading the court had it been made. So we now answered the question, Issue number one, Brown versus Board of Education, 1954. Separate by law can never be equal because of the irreparable psychological harm. And so we can talk more about that. There's plenty to talk about here. The next issue that we need to talk about is what was the legal remedy for de jure segregation? In other words, okay, we've decided this is unconstitutional. What are we going to do about it? What are the courts going to do to fix this? And NAACP Legal Defense and Educational Fund in Brown 2, there was a second Brown case on remedy in 1955, is urging that we desegregate immediately. Let's redistribute the pupils and get this all done in the next academic year. Well, the Supreme Court didn't go for that. They did express concern about the local school problems that would arise. The school authorities have the primary responsibility for deciding, for solving these problems. The courts will have to consider whether the action of the school authorities constitutes good faith implementation of the governing constitutional principles. And what are we going to tell the school boards and the courts that they have to do to implement Brown v. Board? Well, all we're going to tell them is that they need to effectuate a transition to a racially non-discriminatory school system. So with that, we're back in the district court. Now, who appoints the district judges? Well, the president does, right? But who does he seek recommendations from? He seeks recommendations from the senators. And who are the senators? Well, we've got Jim Eastland from Mississippi. We've got Strom Thurmond in South Carolina. Briggs versus Elliott was the Brown case that went up from South Carolina and back down. And here comes the District of South Carolina into the breach that was left by the Supreme Court on remedy. The Supreme Court has not decided that the federal courts are to take over or regulate the public schools of the states, and so on and so on. Under the decision of the Supreme Court, the state may not do so directly or indirectly, but if the schools which it maintains are open to children of all races, excuse me, no violation of the Constitution is involved, even though children of different races voluntarily attend different schools as they attend different churches. The Constitution, in other words, does not require integration. It merely forbids discrimination. So this is the legal basis. In other words, again, we're looking at what is the legal framework here? Well, the legal basis in the lower courts after Brown versus Board of Education was something called freedom of choice. If an African-American child wants to go to a white school, he or she has a right to do it. But if they want to stay in their black schools, they can do that also. And coming back to Alachua County, the complaint in that case was filed in the district court in 1964, 10 years after Brown. And they're still pleading for the reorganization of the entire school system of Alachua County into a unitary non-racial system. In other words, not freedom of choice, but one school system, no white schools, no black schools. Well, what is developing in the South under freedom of choice? In the 1966 to 1967 school year, here are the statistics from the Southern Education Reporter. Alabama, how many black kids are in school with whites? 4.7%. Georgia, Louisiana, Mississippi, South Carolina bringing up the rear. Florida, 20.8%. Alachua County, 13%. And this is from the statistic from Alachua County is from the court report that was filed in the federal case here. So this is where we are as far as freedom of choice. Now, does this mean that African Americans are deciding that they really would rather stay in the black schools? Are they being intimidated and kept out of the white schools? Those are questions which were taken up by the United States Civil Rights Commission in a report in February 1966. And they did find that there was a lot of intimidation, as there would be if African Americans tried to vote, tried to sit at lunch counters, whatever. Same things were going on with school desegregation. They also found that racial identification of the schools strengthens and is perpetuated by normal school ties, which render students reluctant to leave the schools which they presently attend. The Lexington, Kentucky school superintendent pointed out that there is a strong attachment to the Negro high school in the Negro community, even though the Negro high school has known inadequacies. So here's the other side. One Black Mississippi principal stated that because of economic and cultural deprivation, many Negro children enter school much less prepared for education than white children. Until this gap is repaired, he thought dual schools would be advantageous. And of course, there were always fears that African American teachers would lose their jobs. So we are now to 1966, U.S. v. Jefferson County Board of Education, Fifth Circuit, 1966. The Fifth Circuit Court of Appeals at that time covered Texas all the way across the Deep South to Florida and Georgia. This is, ladies and gentlemen, take my word for it, the very most important school desegregation case that was decided by any court in the United States. There were 7 consolidated cases from from Alabama and Louisiana. John Minor Wisdom wrote the opinion. His father was a pallbearer for Robert E. Lee. He came from a very traditional, privileged Southern background, but yet rose to the occasion here. He says, we grasp the nettle. Why is he saying that? Because ultimately, as the Supreme Court found in Brown, this is a constitutional issue. The courts have to decide it. The chickens are finally coming home to roost that were left running around in Brown versus Board of Education. Under the Equal Protection Clause, the harm described in Brown 1, irreparable harm, and the remedy described in Brown 2, the second Brown case, a racially non-discriminatory school system, requires affirmative action by the school boards to establish unitary school systems. No Negro schools and no white schools, just schools. And in that decision, 9 prior Fifth Circuit decisions, many of which relied on Briggs versus Elliott, were overruled. And what does the NAACP Legal Defense Fund see as the remedy here? Again, they want unitary school systems in the next school year. Despite grasping the nettle, the court in U.S. versus Jefferson County Board of Education did not set any deadline. Now, the Supreme Court did not review Jefferson County. And by not reviewing it, that meant, of course, that the Fifth Circuit court decision stood. And as of 1966, in Florida, it was now the law that you had to have unitary school systems. Freedom of choice was no longer constitutional. But the Supreme Court did take up this issue in Green versus County School Board of New Kent County, a Virginia case in 1968. And they said no, and basically didn't even discuss Briggs versus Elliott, didn't discuss freedom of choice, just said in Brown, what we meant was that a unitary school system is required by the Equal Protection Clause. Again, 14 years after Brown, we finally get the word from the Supreme Court. When? Promptly. So what happens next? Well, the South is turning against the civil rights legislation and all the civil rights activity. In 1964, Goldwater Miller won 5 Southern states, 5 Deep South states. In the 1968 presidential election, Wallace LeMay won Arkansas, Louisiana, Mississippi, Alabama, and Georgia. Nixon Agnew won Florida, South Carolina, North Carolina, Virginia, and Tennessee. He became president January 20th, 1969. Warren Burger is in office as Chief Justice June 23rd, 1969. And I want to recommend a book that everybody knows who Leon Panetta is, right? Well, he was a very young lawyer at the time, and in that time, he was the head of the Office of Civil Rights in the Department of Health, Education, and Welfare, principally responsible for enforcing the funding requirements under the Civil Rights Act of 1964. And this is a sort of blow-by-blow discussion of what happened when Nixon took office and Finch became Secretary of HEW. So now we've answered 2 of the 3 questions that we're talking about today. Brown versus Board of Education, separate by law can never be equal. Preempting the whole argument that you could ever have laws that provided for equal but separate education. Issue number 2, the 14th Amendment as interpreted in Brown versus Board of Education requires unitary school systems, 66 and 68. Now, one more big issue, by when? And there is some discussion of that also. Obviously, what is being fought out in the electorate is we don't want an end to freedom of choice. And the Southern legislators are drawing a ring fence, trying to draw a ring fence around freedom of choice, fight back. Various legislative proposals are put in, anti-busing amendments, et cetera. So the action at the Supreme Court continues. The NAACP Legal Defense Fund is not backing off 1 inch. Alexander v. Holmes County Board of Education, October 29th, 1969, 33 districts in Mississippi. Well, here's Nixon, the Nixon Justice Department, urging delay because some of these districts do not yet have plans in effect to put in unitary school systems. Justice Berger, in a draft opinion, agrees and proposes to remand to the Fifth Circuit, October 25th, 1969. And what does Justice Black say? Well, Justice Black by now has had enough, and his view is time's up. And he circulates a dissent on October 26, 1969. These opinions are being passed around to judges' houses at this point. I am opposed to issuing a full opinion. There has already been too much writing and not enough action in this field. Writing breeds more writing, again, 14 years, 15 years later, and more disagreements, all of which inevitably delay action. The duty of this court and of all others is too simple to require perpetual litigation and deliberation. That duty is to extirpate all racial discrimination in our public schools now. And this is from the papers of John Marshall Harlan at Princeton University. Justice Black wins the argument. The court unanimously orders the Fifth Circuit to enter a decree stating that immediately the school districts may no longer operate dual school systems. The Fifth Circuit orders unitary systems by January 1, 1970, the middle of the school year. Another book that I highly recommend, Willie Morris, who was the editor, I believe, of The Atlantic, graduated from Yazoo High School in 1971, whenever he graduated. And in 1971, he wrote the book Yazoo about going back to his high school and seeing what was going on there and describing that community desegregating. In January of 1970, in response to the Alexander case. So we have now answered issue number 3 by when, immediately January 1, 1970 in Alexander. For Alachua County, there was another case of kids that went up just right after Alexander, February 1st, 1970, for Alachua County in the Carter case. And before the Fifth Circuit, that case was named Singleton. So now we've answered all the questions. This is the legal framework in which desegregation took place. This is my last point here. What was the impact? Well, from 1954 until 1968, 1969, everyone had reason to believe, that is the students, the school boards, the colleges of education, the teachers, everybody, that Southern school districts could continue to operate their side-by-side white and black schools indefinitely. And next week, we'll take that theme up. But that concludes my presentation about the legal impact. And I'm now going to throw this open for questions. I believe we've still got quite a bit of time for questions and discussion. Okay, so I want to get out. Tell me how I get out of screen sharing.
There's a green tab, little marker that says stop sharing.
Yes, got it. Okay, thank you.
All right, so we have time for questions. John Spindler, I'll kind of go to you first to see if you have any comments or questions before we go to our.
Well, Michael, in talking to you, and of course, as I introduced you this morning, you were a corporate lawyer for a large portion of your working life. And that seems to be an unlikely background for an author of a book. What made you decide to write We Can Do It?
Well, I became aware, I was investing in an angel fund located in Gainesville. And I remember driving back from the Jacksonville airport, I'm listening to public radio and hearing for the first time about the Lincoln High School protests against the closing of Lincoln High School. And in the back of my mind, I said, this is there is a serious community issue here. And I filed that away. And when I had more time to dig into this, I decided that I would see whether it was feasible to write something about it. I had intended to become a print journalist and went to law school. Fortunately, it was a good choice, right? And so I met with some former teachers. I met with the NAACP here to see whether there would be support for a more in-depth look at school desegregation in Alachua County, knowing that there were significant community issues here. And I received a lot of support for the idea. I plunged in, and the rest is history, I guess. That would be the answer to that. Certainly any of the skills that I had as a lawyer, writing briefs, doing research, investigating things, whether in a corporate transaction or in a trial or appellate case, would have served me well, because that's a skill that I needed in order to dig into this subject.
When I looked through your book, Michael, and it's rather formidable, over 500 pages, I noticed that, and this helps answer the question I would have had, the references in the rear there make up almost over a quarter of the book, because there are so many people that you interviewed and all the readings and the investigations, research that you did to serve as a bibliography for the fact-finding. How did you go about investigating in order to come up with the facts?
Okay, well, why don't we save that? Why don't we save that until next week?
Okay.
I have reserved a bit of time to talk about that next week, and I think it's probably more appropriate coming in right before we talk about the Alachua County experience, if that's okay with everybody. But I'm, I'm a lawyer. I was an American history major at Columbia and wrote academic papers there. I had this, whatever skills I had, I brought to the project, and that was the output.
I have a question. Given the roles that Thurgood Marshall on the national scene and the Reverend Wright here on the local scene as heads of the NAACP who pushed for immediate unitary system, I wonder if there are groups of Blacks who maybe still hold a grudge against these two men whom we've thought of as heroes to the certainly the African American community as well as to many whites, because they obviously were going against the wishes of many Blacks.
The answer is yes, and that's next week.
Okay.
Yes, we're going to go there next week.
Okay.
I mean, we can start talking about it now if that's what people want to talk about, but it's your show at this point. But the purpose of this week's presentation was to talk about how we got to the idea that we were going to have unitary school systems. And perhaps just by way of, I don't know if I can do this, if I can technologically manage to open my other slide set. Okay, now I need to share screen again. Can I do that? Yes. Okay, here is what the Jefferson County case said about unitary school systems in 1967. We'll save some time next week. This was substantially as proposed by the NAACP Legal Defense and Education Fund. Facilities, equipment, and courses of instruction and instructional materials in schools formerly maintained for Negro children shall be of a quality equal to that in white schools. So far, so good. If for any reason it is not feasible to improve sufficiently any school formerly maintained for Negro students, such school shall be closed as soon as possible and students reassigned on the basis of freedom of choice. New schools and any substantial expansion of existing schools shall be located with the objective of eradicating the vestiges of the dual system. And so here we have the idea that, well, we've got a lot of school plant that was maintained for African American students. It's probably subpar, it's probably located deep within African American neighborhoods. If we're going to make school desegregation work for everybody, we're going to have to build some new schools. If we're going to build new schools or expand existing schools, those investments need to be made in areas where there is a possibility that Black and white students will attend. Again, right or wrong, that's what the courts decided.
Michael, I do have a comment in the chat box if you'd like me to read it.
Go for it.
It says, it's from one of our participants, says, I was a teacher in Hillsborough County from January 1970 until June 72. The single Black high school in Tampa was closed in June of 1971. A new high school was to open in August 1972. Black students were bused all over the city. Lido High School went on double session, integrated Lido students in the morning and the new integrated Jefferson High School students in the afternoon in the Lido building. Racial clashes were a daily occurrence.
Yes. Yes, Blake and Middleton were both closed at that time. We, just to answer this question, we of course had a similar situation in Alachua County where we did not have new schools up at the time that desegregation occurred in February of 1970. And all the Black students in the county in grades 10 to 12 were sent to Gainesville High School, which was built for like 1,600 people. It had 3,200 people in it, students, and we had the same type of experience. Just to fill that out, the school board later did build a new Blake and a new Middleton High School. And those are now, they're located in the former neighborhoods. There are magnet programs there, and there's some desegregation. The schools are doing well, but they are not, they do not have the same, despite the names that they're bearing, they don't have the same identity, racial identity, and community identity that the former Blake and Middleton had. And I should point out that, again, this is for next week, but virtually every Black high school in the state of Florida was closed at that time.
Barbara, would you like to, you're unmuted already, okay.
Yes, this is probably a segue into your discussion next week. I was really fascinated by the material you presented today since I moved to Gainesville with my 4-year-old son, well, about to be 5-year-old son, in June of 1971. And the first thing that happened, the second night we were here, a colleague of my husband showed up at the front door with 2 things: a coral snake, a dead coral snake, since he was concerned that these Yankees would not know what a coral snake was, and an application to a newly established private school. And he said to us, "You cannot send your son to the public schools. They have just been integrated. It is a dangerous situation. Here is the application for the private school." It took us aback because we had fought for integration of public schools in Cleveland at a very difficult time. And we did end up sending our son to the public schools. It was a rough experience, and I suspect you'll talk about that next week, but I have never forgotten the shock I had between the coral snake and the application for the private school.
Thank you.
John B., did you have a comment?
I have another question here. Well, it went away. John Brower had a question.
Yes,
John,
Mike.
do you want to unmute and just go ahead and ask it?
Hey, yes, Mike. You emphasized the importance of the Jefferson County decision in 1966 and 1967. In what state is this Jefferson County?
Okay, this is in the Fifth Circuit Court of Appeals, the U.S. Fifth Circuit Court of Appeals. It's a federal court case, as were all of these cases. It came up from Louisiana and Alabama, school districts in Louisiana and Alabama, to the Fifth Circuit Court of Appeals.
Okay. So Jefferson County is
Does that answer? Go ahead.
in what state is this Jefferson County? Is it Louisiana or
Oh,
Alabama?
Jefferson County is Birmingham, Alabama. Sorry.
Okay, very good. Thank you.
Someone else had a question.
More questions.
There is another
Okay,
comment
I see in
chat.
Broward County, the Black schools in Black neighborhoods remained open, but were made into magnet schools in an attempt to integrate them. However, the magnet schools remain pretty much a group by themselves. This is from John Lowenthal. And that's, I guess, a comment, which is certainly I would agree with that comment.
It's Jan.
In Volusia County in 1975, when we moved there, the Black High School Chisholm had been made into a magnet school, and it was in very poor repair, but it was that. And as time went on, it was upgraded and expanded, and you know, things went about as smoothly as they could, I think, there in Volusia County.
Well, good. And I would add in Volusia County that Rains High School was opened as a Black high school, a segregated Black, well, under freedom of choice, of course, but as a historically Black high school in 1965, and was probably one of the last Black high schools to be opened in the state of Florida. And of course, it was still constitutional to do that under freedom of choice. Rains is still open, and very much, if you go on the Rains High School website, I'm a nerd, I mean, I do all this stuff, right? There is a very much, a very significant community spirit around that high school as an African-American institution.
This has been wonderful. I don't see any other questions. John Spindler, do you want to have any final comments?
Well, I think this sets the tone for a foundation, because there'll be a lot of interest in actually what happened when the rubber met the road here in Gainesville or Alachua County in 69, 70. And of course, I moved here. I came back to Gainesville in 1968, right after the teacher strike. And that's where I got my baptism of fire. And so I'm looking forward to Michael's rendition of that. Of course, I've read the book, and that gives me a significant advantage there. Plus, I lived the life as a principal. And so anyway, I think that's fine. We look forward to next week at the same time on Wednesday.
Very good. And I would just mention that I had if people are wondering about my black eye, I had a cycling accident last week. Everything's fine. I rode away from it, but I obviously have some bruises and scrapes.
Well, thank you, everyone. Thank you, Michael, for joining us, and we look forward to seeing you all in a week for part 2.
Very good. Thanks,
Thank you.
thanks
Everyone stay
everybody.
Thank you, Michael.